Schools desegregation is the effort undertaken to dismantle segregated schooling. And here I want to make a distinction between desegregation and integration. They're not the same thing. Desegregation entails ending the use of race to assign students to schools in a manner that creates racially identifiable schools. Desegregation is necessary but not sufficient. And that's different from integration. Integration describes a quality of relationship and the interaction between individuals previously segregated. In order to achieve the educational and societal goals that are consistent with our norms of social justice, integration is a necessary goal. Far too often we conflate integration to mean no more than desegregation. And therein lies a major policy flaw in our last 50 plus, 60 plus years of efforts to desegregate the nation's schools. One example centered on the segregation, desegregation, integration process is offered in Gordon Allport's 1954 work on prejudice reduction. Allport gave us 4 conditions for integrating previously segregated groups. The first was equal status. That when children come together in school, they ought to be brought together understanding that they have equal status. A shared or common goal should be the way in which they work together in classrooms and in schools. There needs to be more intergroup cooperation. And the fourth of these is the support of the authorities, law, or custom. So teachers, educators must endorse, approve, and support this set of relations that are evolving among kids who have been previously segregated. Oftentimes we think of these things as having been resolved, but if you look at the history of this effort, you'll see that not only have we persisted in bringing the case before us in terms of law, but you'll also see that there's been tremendous resistance, different efforts in different places that have tried to thwart or curtail or simply reduce and restrict and limit our efforts to integrate the schools in this country. In Brown, the call for states to implement school desegregation, root and branch, ruled in 1954. We've been persisting at that since then. We've tried in a variety of ways. The Civil Rights Act, which was really the Public Accommodations Act, was about federal prohibition of places that were restricted access or restricted entry points and so on. All indicators of the misuse of race to separate. University of California versus Bakke was a critical ruling in this effort to integrate our schools and the effective use of race. And one of the things that changed with that was this introduction of this term, compelling interest, that the states could have a compelling interest to provide a diverse learning context and that there would be benefits of that diversity. The introduction of the diversity concept has not been widely embraced by all scholars or politicians and policy people in this effort. The problem with the concept of diversity is, in fact, in the very definition of it. What do we mean by the diversity? To some extent, there are some who feel that by emphasizing diversity, we look at any number of differences, but it detracts us from the fundamental issue of the racism that undergirds the separation of Black and Hispanic communities and thereby their students from whites, and how that interacts with limited access to the quality of educational experience and other mobility resources that these communities and the children deserve. So what are the main points I want to make here for you? I want to talk about how much segregation there is just briefly, and why does segregation matter? Do we achieve integration when we desegregate, or do we need to do something more? And again, I repeat, desegregation is necessary, but not sufficient to achieve the benefits of diversity. On June 28, 2007, the Supreme Court issued 2 rulings in related cases, examining the use of race by K-12 public school districts as a factor in assigning students to schools. At issue was the constitutionality of desegregation policies voluntarily adopted by the Jefferson County School District in Louisville and the Seattle School District, asking whether these race-based student assignment policies violated the Equal Protection Clause of the 14th Amendment to the Constitution.